And violations are not always going to be black and white. There's a lot of nuance in there. So we will talk about that. And there are some overlapping topics here, like substantial improvement in damage and permitting, but I'm going to try to stay on topic and just focus on the violations aspect of it. So what is floodplain management? Basically, it's a community-based effort to prevent or reduce the risk of flooding, resulting in a more resilient community. So basically, we're taking into account the flood risk and the functions of the floodplain and trying to use them wisely and manage development in such a way that we reduce the risk to property and life. So that's the whole goal of floodplain management, is to reduce that damage and protect people and property from becoming damaged. And so we have these regulations in place as a compromise from allowing people to do development and not completely barring it, but if they're going to do it, it needs to be done to such a standard, performance standards that are reasonable to keep it from flooding. So that's our whole goal and why we do enforcement and correct violations. Or you could think of it as a stick to beat your neighbor. So if you're not familiar, this is Steve, who is one of our predecessors, who put this presentation together, and you'll see some of his humor throughout the slides. But the point of this is that a lot of violations do begin between neighbor disputes, and those complaints come in and they just are trying to get each other in trouble. But as soon as we become aware of a violation, we need to do the enforcement. And so it can open an entire can of worms. We have had that happen before, where complaints about development come in and this whole neighborhood was in the floodway, and then it turned out a bunch of development had happened unpermitted without no-rise certificates. And so yeah, it can open a whole can of worms, and you'll be dealing with these disputes. So that is something common that happens in floodplain management between neighbors. And a whole lot of violations and dealing with violations can be dealing with very emotional people. And so I have been to some of these meetings to help the floodplain administrator, and people are just very upset, either angry or sad. So just be prepared for that if you're not, very experienced. If you're still kind of new to floodplain management, that is a big part of it. So a violation is development that has occurred within the special flood hazard area that does not meet the minimum requirements of the local floodplain regulations. So not having a permit is a violation. And so not having a permit usually means we have to go back and retroactively permit development and make sure that it's in compliance. And that's the whole point of doing the permit, is to make sure that things are in compliance. Because if they're not, they will be vulnerable to flood damage. The insurance can be very expensive depending on the nature of the violation. And FEMA could potentially impose sanctions on the community if you're not doing the enforcement. So violations will happen. It's kind of impossible to catch every little thing. I do have some tips on how to monitor that, but people will knowingly or unknowingly commit these violations. So you will have to deal with it at some point. And if you're not doing the enforcement, or if you're not doing it correctly, and we will talk about that a little bit, FEMA could potentially put the community on probation or suspended, which means you're basically kicked out of the program. So that's not very common, and as long as you're working towards fixing the issues and getting compliance, that isn't going to be a problem. And then of course we're always here to help you with getting compliance from people as well. And development means any man-made change to improved or unimproved real estate. So that means structural development, non-structural. It includes levees. Mining, dredging, filling, and grading are some of the bigger types of activities that happen in the floodplain that would probably need state and federal permits in addition to your local permit, paving, excavation, drilling, and then storage of material and equipment is a very big one that I find all the time when I do audits. And so it means any man-made change. So really any work at all in the floodplain should have a permit. And that includes interior renovations or rehabilitations, because that counts towards the substantial improvement category. And I said I would get into that a little bit later on. So that should have a permit, and even maintenance of the roof, which is another big one that comes up quite often. And again, it does count towards substantial improvement, but we will talk about how you can exempt some of these things from needing a permit. And so that way you won't deal with those violations that are not going to cause an obstruction. So just to be aware, all development, I answer this question all the time, what needs a permit? Everything is supposed to have a permit. And so this list is not all inclusive. As I said, it includes maintenance and repair. So there are easier things to permit, but it does need to be documented. And so letting people know that they need permits is a very big part of that. So there's a sign here, and I'll show you a few other examples of public signs, but I recommend doing certified mailings, like annually do that outreach to your floodplain addresses. And then some people will still claim to not know, but at least you'll have, documentation that, yeah, you should know this because I, sent you a message, like a letter, saying that you're in the floodplain and you need a permit for all activities, and then give them your office information and where they can find the ordinance online or at City Hall or whatever the case may be. I've been thinking about putting a template together for that annual mailing. That might be a good idea, but just that way no one is caught unaware, because sometimes violations will happen and people really just did not know that they were supposed to have a permit. And in that case, they are usually pretty eager to, correct themselves. Other times it's done on purpose because people don't want to get a permit, but that way, you know that you've reached out to these people. And we'll talk a little bit more about doing outreach here. Like I said, public signs, brochures, if you can put it on your website or your social media, just however you can get the word out to let people know about the floodplain, where it's located, and that they need permits to do development. And so another very common violation that we find in our audits is accessory structures. So just these small storage sheds. And so if they're going to have them in the floodplain and not elevate them, they need to be wet flood proofed, which means that they're equipped with flood openings. And so we have a lot of these companies that will just deliver a shed to you and they're not wet flood proofed. And, they also have to be anchored and made of flood damage resistant materials. So if you know of a company like this that serves your community, you might want to do the same outreach to them as well. And that way they know that the structures that they're delivering to people are supposed to be wet flood proofed and made of certain materials and be anchored in the floodplain. So we can't, guarantee that they're gonna do anything about it, but at least then they're made aware and they can't claim that they were not made aware. So that might give you an advantage, and it will help you to prevent people from accidentally, committing these violations. So a lot of people get kind of upset when you're telling them what to do on their own land. However, we do have the authority to enact and enforce our floodplain regulations. So what gives you the right? We have several zoning laws in Kansas that give us this right. And so KSA 12-766 and 767 are, oh, and 768, sorry, are the floodplains. This is what, where you can find the actual state authority that grants you the right as a community, as a governing body, to adopt and enact these regulations. And so that law or those laws are cited in everyone's floodplain regulations. It's usually one of the very first thing is the authorization. And then there's administrative regulations, and then zoning laws about dangerous structures, insurance proceeds and abatement. And so we'll go through what these mean, especially the insurance proceeds. But basically, if there are dangerous structures or if there's a nuisance in your community, you have the right to correct those things and then put a lien against the property so that they pay for those corrections. So if you're curious about that, definitely take a look at these laws that give you the right to correct at least that type of violation. As far as other floodplain violations, you should have a violation section in your ordinance, and we'll take a look at the state template section on doing violations and enforcement. But if your ordinance is over 10 or so years, first you should just update the entire thing, and I can help you do that. But also your violation section may not be as fleshed out as what we have now. So you might want to take a look at what your violation section looks like and then see if you might need to beef it up a little bit. So whatever your ordinance says, you have to enforce that. Whatever you've adopted, you are obligated to do the enforcement on that. And then there are other state agencies such as ours, the Division of Water Resources, that deals with state violations. So there are state laws that apply to floodplains that are completely separate from the NFIP. And as I said earlier, that usually pertains to doing dredging, excavation, or fill in the floodplain. That type of work might need a state permit. And so if you're not sure, you can always check with us if you need a state permit. That's just kind of a good rule of thumb, if you don't know, to just check with us. And there's also KDHE, or Department of Health and Environment. They also have rules about floodplains, such as no septic tanks. And again, that is completely separate from the NFIP. So just a little bit of background on authorization and state laws that pertain to floodplain management and, well, in turn, violations. So the insurance proceeds, so this is an ordinance that you can adopt where basically any damage, like substantial damage, you can withhold 15% of their insurance payout to make sure that they come into compliance, and then you will withhold that 15% until that is done, until they come into compliance, and then you would release it to them. So I have not had any communities adopt this since I've been here, and I'm not sure if anyone does have it adopted, or if they did, it was a long time ago. So I just wanted to bring this out. This is another state law that we have that you can do this if, with these specific stipulations, it talks about, how much the covered claim, if it's in excess of 70% of the face value and all of that. But, I'd be happy to work with anyone who'd be interested in this. But it can be used as another compliance tool that we have, but I'm not super familiar with it because I haven't, as I said, worked with it, but it is just for your awareness. This is something that you could potentially adopt and then have as another tool to make sure that people come into compliance. And this relates to substantial damage, which, if they are damaged from any cause that is 50% or more of the market value, they're substantially damaged, and then they have to bring the structure into compliance with the current ordinance. So that usually means having to elevate it if it's, an older structure that was built before the current maps, or if your maps have changed since that structure was built, it could be that it might need to be elevated. So that's usually one of the more difficult aspects of compliance is getting people to elevate an existing structure. That is usually a spot that we get hung up on, but just for your awareness, that is usually substantial damage. And if it's already elevated, then it's already considered to be in compliance and they don't need to do anything. But yeah, just pointing that out. So when does enforcement start? Is it when you first become aware of the violation, when a complaint comes in, when you visit the property, or when we're doing an audit? Technically they're all true, but really when you first become aware of the violation in whatever way, shape, or form you became aware of it, and these are all examples of how you might become aware of it. As I said, neighbor complaints, also a big one. However you find out about it is when we have to start doing the enforcement. And so, we don't rely on complaints or written complaints. Basically, we want to document everything everywhere. So as soon as we become aware of the violation, we start investigating whether it is actually a violation, how it's a violation, and what we can do about it. So we'll go through that process, but there are a lot of excuses that we hear for people not wanting to enforce their regulations. And I've heard variations of all of these. And the last one is pretty recent and new, where they're trying to tell me it's not in the floodplain when it very clearly is, and I'm showing them the map and everything. Also, banks are taking care of it. Banks do not do floodplain management or enforcement. They are strictly dealing with insurance and insurance purchase requirements and making determinations on if people are required to have flood insurance. And that's it. They're not really concerned with violations. Violations through insurance policies can get back to FEMA and then they give it to us to deal with, but definitely banks are not doing any part of that. I'm too busy. We understand that floodplain administrators often are wearing multiple hats. You have other duties besides being a floodplain administrator, but again, we are obligated to enforce the regulations that we adopt, and that is kind of the whole crux of this program, is that you enforce regulations, and then that's why federal money is available to you for grants, disaster assistance, and flood insurance. You don't want to upset anyone. As I said, you are going to deal with emotional people who don't want to, correct their violations, or people who can't afford to, and it's upsetting, but we have to, again, enforce these regulations. And yeah, dealing with emotional people is just part of it. It's already built and done, so it's too late now. Again, an unfortunate situation, but it's not over just because something is built. We're dealing with a violation like this right now where it was built too low because the contractors misread the elevation that it was supposed to be at, and now we're dealing with that situation. It's not okay just because the construction is now complete. It still needs to be elevated. The violator is the mayor's brother or the mayor. We deal with that a lot as well. There's, all these inner politics that happen. Again, it's not an excuse to not do the enforcement. It's DWR's fault. I'm not authorized to do the floodplain management in anybody's community. That is part of the authorization, is the floodplain administrator has the authority. I don't have any authority in your community necessarily, unless, we're talking about a state violation. I just assist you with doing your floodplain management. We don't do that here, or we don't have procedures in place to do that. You need to have procedures in place to do that. I am dealing with a community right now that just told me they don't do permitting, they don't have zoning, and they were just looking at me like, that is valid. Basically, we have to do permits, and your regulations have an entire section on permitting, and it says that people are required to get permits to develop in the floodplain. So that is really, not valid. I'm protecting my community from FEMA by not enforcing FEMA's rules, which is a strange take on it. Again, there's the exchange of federal money for doing the enforcement. And I have been called a Soviet and many other things for trying to enforce these rules. But you're certainly not protecting your community if you're not doing enforcement and making sure that things are built safely. And you could be held liable if you're not doing that and then someone gets hurt, or if there's a lot of damage. So you're definitely not protecting the community by not doing enforcement. And again, it's quote unquote not in the floodplain when it clearly is. So just a handful of excuses that we hear a lot. We have to do enforcement. It's part of the program. And then if I hear these excuses, I'm likely to sign you up for an audit. And the audit process, again, is meant to be a learning opportunity. It's meant for us to help you address any deficiencies in your program. It's not supposed to be a punishment. And really none of this is supposed to be a punishment for anyone. It's a safety issue, and that's why it's important, and that's why I care about it, because people and first responders could be put in danger, and that's really the most important part. So FEMA doesn't really give anyone any free passes, and if they become aware of it, they're definitely going to make sure that you are following through on those violations. So what is the key to doing enforcement? Consistency. We need to have a procedure in place, and this is where written administrative procedures come in again. Procedures in place to make sure that we are treating people fairly and equally throughout the community and having a consistent process to avoid any issues. So we don't want to give anyone preferential treatment or anything, although it does happen. People could accuse you of being inconsistent or showing favoritism to someone or discrimination, and we don't want to incite that. We want to avoid that. So that is where having a consistent process written out, having it in writing, can be very beneficial to you. So I'm going to send a follow-up email after everything, and I'll put our written administrative procedure template in there. And then you can take a look at what we have as a violations process. So it talks about doing inspections and sending notices and doing the enforcement. So again, you want to be consistent with all of your citizens and do things fairly and evenly across the board. So aerial imagery is something that can really help you. You can look at the GIS data, take a look at our effective floodplain viewer before you go out. You can make a map before you visit a property. And so we'll talk about setting up meetings with the violator or potential violator and sending them notices. But aerial imagery can help you detect violations where you might not be able to see clearly. So this is what I do before I audit a community. I check aerial imagery of the floodplain over the last couple of years and just look for new development. And then I'll ask for those permits or for you to do the retroactive permitting. So this is something that could help you if you just did that same process periodically. It will depend on what aerial imagery there is available for your community, but it could be like another tool that you use to find violations and then hopefully address them as soon as possible, because the longer you wait, the worse it tends to get. So again, you don't want people to claim discrimination or anything, and then have them complain to officials. So that's why it's important to, again, be consistent and then document everything. You want to over document stuff because, again, these cases can go to court potentially. And so, we want to document everything, be consistent, be fair, and then, just having a map like this can help just identifying it as new development in the floodplain. And so you might make a locator map like this, just Google Maps, to find the correct address, because again, it could go to court, so we're going to be potentially needing that legal description, the parcel number, and everything like that. So you want to probably make a ferment if you're dealing with a case like that. We have plenty of videos on how to do that, but there are multiple ways. Just making a floodplain map of the area of interest. And then keep that with your permit forms, because again, we want to document the process thoroughly. So this is an example of something that I might see. I wouldn't be looking this far back, and neither would you. We're talking about the more recent years, but in this example, it's clear that there's been a new structure put in place, maybe some regrading for that driveway area. So it's clear that there's been change here. So a new structure is going to need a permit. It should have an elevation certificate. So you want to look in your permit files and see if something was put on file for this structure. So, and if there's not, then saving this type of imagery and keeping that as documentation with your permit files is a good idea. And just documenting how you came across the violation or potential violation, and just having that to back you up as you address and try to get compliance, because this clearly demonstrates that there's new development. So they can't claim that it's been there forever or whatever the case. So there are various ways. I think the easiest way is probably Google Earth. They have like a timeline. So whatever imagery they have available, you can just click through that. There's also the Wayback app that might have other imagery that's not in Google Earth. So I can just make a note to send you guys that as well. And that way you'll have that if you are interested in, just taking a look at your floodplains and see if there's anything that you may have missed. And then reviewing the files or building permit records. So, you are probably going to need to do some amount of homework before you head out into the field, and you want to make note what records that can be found for this property. And again, this whole thing could go to court, so you want to put together this case file so that you're familiar with what has happened on this property as far as documentation, and then again adding your documentation as you go along. So appraiser property tax records will have the dates of additions or other construction, and that might be of assistance to you as you go through and try to document new construction. Again, you might want to check the previous flood maps. So if you see new development, it could be that it wasn't in the floodplain at the time that it was built, or something like that. And that can help you evaluate whether you actually have a violation or not. And so again, the first part of this is doing the homework. You're doing the background work, and sometimes this will help you evaluate that you don't have a violation. For example, we had something like this and the permit was not filed correctly. So they did get a permit. It was in compliance. They just misplaced that permit record. So things like that can happen. And like I said, maybe it was built and then mapped into the floodplain. So things like that are possible that mean it's not a violation. So if you are going to go do the inspection, you think there's a violation, it was in the floodplain the whole time, there's no permit on file or anywhere that you can find, we think we have a violation, and you're going to go in and do the inspection. So I will talk about our standards for, notifying the property owner and, getting permission to enter private property. And we'll talk about, not trespassing and stuff. But once you are there and you're doing this, you're going to want to take lots of photos and take an establishing shot. So this is a great close-up of new development that, may not have been permitted. We don't know if it's in compliance or anything, but again, you might want to, take, again, lots of pictures and then do an establishing shot so that we can establish exactly where this is, and then you won't have a property owner that can lie about it. Because this has happened where the floodplain administrator went to court and the property owner was just trying to say like it wasn't their property or something like that. And a lot of sheds, for example, would look the same. So here's a good establishing shot. We have the house numbers on this structure, and then you can see, the surrounding area. And if you'll notice, we're standing on the public property. We're kind of on this traffic island. We don't want to get anywhere on the property without permission or without following through on the notices and everything. So I'll get into that, but basically don't trespass because that could cause you issues when you're just trying to resolve issues and, get through a violation and do the enforcement like you're supposed to. We don't want you to get in trouble while you're trying to do that. So don't trespass, don't go onto the property if you haven't gotten permission or done the notice process. So we're standing on public property and getting a wide establishing shot that shows us exactly where we are, and it's not arguable that you're somewhere else. So you have a wide angle photo. You want to use unaltered photos, so don't alter them. You want to save the metadata and have that raw unedited image. And again, we're thinking potentially any and all cases could go to court. So that's why we're being very thorough. We're following the rules and getting an establishing shot. And you might even want to put like the timestamp date on there, have that setting on your digital camera. And try to include a landmark. So in this one, we have a fire hydrant. And again, that just helps us to establish the exact location. A street sign is a really good landmark. That might be the best one to have if you can. Of course, you won't be able to do that all the time, but just having something there to show us exactly where we are. So this is a picture of a house that was flooded and substantially damaged. So that's why all of those belongings are out in the yard. And, when you're doing those assessments, you're also taking establishing photos. Pretty much anytime we're doing floodplain stuff and taking pictures, we need an establishing photo. So this one has the street sign in there and it shows us exactly where we are at that intersection. So if possible, street signs or some other type of landmark, and that will, help you later on if you're sorting through photos to get organized. But yeah, just whatever you can get. Again, where do we stand when we're taking the picture? So the Fourth Amendment deals with unreasonable search and seizure. So again, you don't want people saying that you're infringing on their rights, and that will come up several times throughout the presentation. But in this case, we're talking about curtilage, which basically means the surrounding areas of the property, like the front yard, are basically protected the same as the inside of someone's house. Like it's basically the same rules of doing a B&E or like a breaking and entering. It's treated the same way and it's trespassing. So, which doesn't make a whole lot of sense to me, but that's how they look at it. So that's why we're standing on public property. I'm always taking pictures from public property. And so just something to be aware of and, not, do the trespassing. So, Boston Tea Party. So this is where that stems from when they were doing illegal search and seizure and how we got the Fourth Amendment. So just a little bit of background on that. It's not super relevant, just do so from public property unless you're working with the property owner and you've gotten permission. And then I'll show you the section where it talks about not having permission, but doing the conspicuous notices on the property and that kind of thing. So we'll get into that. Again, we don't want you to put yourself in danger. We don't want you to get shot or anything else that could happen here. Safety concerns. Safety concerns also come into play when we think about retaliation. I have had some floodplain administrators that are afraid to do enforcement for fear of retaliation, which I guess might be the most valid excuse that I've heard. It's not an excuse. Danger could be, a potential concern. And so let us help you with that. If you are afraid to do enforcement because of the fear of retaliation, we might be able to step in and assist you, or at least take the blame, and we'll talk about that as well. Again, numbers on this house, another way to establish, that this is the right structure. And you can show this to the property owner and ask them if this is their house, and then they would have to say yes, and then you have the pictures of the violation. So that's the thought process behind that. So you show them that shot, yes, this is your house, and then you would ask them about the shed. And that way they can't argue with you that it isn't theirs or it's not their property, or whatever the case is. Okay, and then just a little bit of note about how you want to take pictures. You might want to have a cheap digital camera that you just use for violations and enforcement. And that way, if it gets confiscated for some reason and the property owner's claiming that you altered photos or something, they may want to see the device and the raw data and all of that. So you can just get an inexpensive camera for about $100. And of course, we have plenty of, high resolution photos and pretty unlimited ability to take photos. So that's, great for enforcement. And that way, again, if your camera gets taken away, it's just a cheap digital camera, and it might be better than trying to use your phone or something. Take multiple pictures. Of course, digital pictures are free at this point. We don't have to go and get them developed anymore. And you would want to work with your city attorney to choose photos that could be used in court. And so hopefully, I know not everyone does, but if you have a city attorney, you'd be working with them to choose those photos and just the entire enforcement process. You won't need a selfie stick, and again, save the metadata because that might come into play. And then Steve liked to point out that BTK was the code enforcement officer in Park City, I think. And so he was a floodplain administrator. Just fun fact. So another thing about privacy fences, don't lift your camera over a privacy fence or try to violate someone's privacy. Again, that's a Fourth Amendment issue. A privacy fence is meant to provide reasonable privacy. So if you go and try to negate that, then you're, going against the rules again. So that's an example of what not to do. So don't do that. You could get in trouble, especially if you end up capturing, people in your pictures or something like that. Don't do that. Don't use a drone. You don't want to be flying a drone over someone's backyard. We did have a floodplain administrator that would rent a cherry picker, and then they would try to like raise themselves over the fence and take pictures that way. We don't need to do that. Most of the time, if there's something like a shed, you can see it, in both of these pictures reasonably well, enough to establish that there is a shed there. So you don't really have to go and do, like try to violate their privacy. Aerial imagery is fair game though. So again, that might give you a better view than you would be able to have otherwise. So highly recommend using the aerial imagery. Again, document everything as if it will go to court because it could. And again, that's the extreme. I haven't seen anything go to court since I've been here, at least not that I've been involved in. Uh, most things can be resolved without that. Definitely let us know if something is getting to that point. I'd like to help you and get the experience, but again, good records are really important if things didn't work out and you did end up having to go to court. So having that record is very valuable when someone wants to complain about you. You can, back up what you've done and show what you've done because you have all of that documentation. So just something to keep in mind. We can look at a few violations. So this thing, which is not very much a structure, it's not in compliance with the standards for an accessory structure in the floodplain. It's not wet flood proofed, it's not made of the right materials, it doesn't have flood openings, so this one is clearly a violation, and we doubt it has a permit, or at least it shouldn't have been permitted to be built like this. And then there's some that look like a violation. So this may or may not be anchored. It definitely doesn't have flood openings and it's built at grade, but it turns out this one is from like the 70s. So it's quite old and it's a pre-firm structure. So it's okay. It's been grandfathered in until such time that it's been substantially damaged or improved. So this one's actually not a violation. So not everything looks like a violation, or everything that, not everything that looks like a violation is actually one. So again, this might be where aerial imagery can help you out to see how long something has been there. And again, any development without the required permit is a violation. So again, doing the outreach, try to avoid violations by letting people know that permits are required in whatever way that you can accomplish that. Again, blaming me. So people can get upset with you. Why are you doing this to me? It's unfair. You can say that we became aware of this somehow and are making you do the enforcement. Sometimes that can help people, uh, you know, accept that the state is stepping in and that we're requiring you to do the enforcement and get compliance and then send us the documentation for whatever reason. Sometimes that has helped. Just let us know if you're going to do that, and that way if they reach out to me or have questions, I know what's going on and that you've blamed me for it. So that's fine to do. Again, I talk to property owners all the time and they're upset, and I can be more of a neutral party, because I'm with the state and I don't live in that community most of the time, or have any, personal ties to it or anything. So I can assist in that way, and sometimes that will help. Also, you can copy us on violation notices, and that way we can be aware of it and check in and provide any other assistance that you need. And sometimes just having, the state names on there can add a little bit more weight. Sometimes it doesn't help, but it could. So the stop work order is something that you can issue if the work is in progress and there's no permit, basically demanding that they stop the work until such time that they submit the documentations that you need to issue them a permit. So this is another tool that we have to get compliance. You can stop them from doing the ongoing work, and just something else that we have. So I know Nebraska has like state laws regarding stop work orders, but I don't think there are any in Kansas, at least not that I can find. So I don't see any reason why you wouldn't be able to issue one. Right, so it should be issued if the construction is taking place. And then the violator needs to be notified. So we suggest doing certified mail to let them know, and we'll look at some violation notices, but you might want to do that with a mailing affidavit as well. And that way it was received. Sometimes people don't want to sign for certified mail if they're expecting bad news, so a mailing affidavit might be better than a certified letter, potentially. And then this is what the affidavit of mailing looks like. The notary public witnesses you mailing the letter. I think this is also less expensive than doing certified mail. And then, if the property owner can't claim that they never received the letter, basically. So the letter of allegation, the first notice is the nice letter. I say that with quotes. Basically, we're like alleging that a violation may have occurred. We're doing the investigation, so we're like, what's going on here, basically. So we'll take a look at that. Try not to make it too technical. Don't use acronyms. The location and the nature of what we're suspecting may have happened. We want to reference the ordinance and cite the exact rules in the ordinance that may have been violated. So have that citation in there. And then you can go over the consequences a little bit. What could possibly happen if they don't take action? Put a deadline in there. Usually 30 days, we do have to give them due process, and they should be informed of what we want to happen, what needs to happen. This should be removed, or it needs to be elevated, it needs the flood openings, or whatever the case may be. And so sometimes this will, you know, move them in the right direction, and you can get compliance pretty easily this way sometimes. So again, sometimes they didn't know that they needed permits for whatever reason. So sometimes when they get this letter, they will just go ahead and remove it or fix it, or just come to you for a permit and figure out what they need to do and be very, you know, willing to fix it if they did it inadvertently. And then the problem has resolved itself, and, you know, case closed, and, you know, it's not a problem anymore. So we need to send it to the actual property owner. Why not just the person living there? Well, if they're a tenant, they don't own the property, and they may not, you know, care about it because it's not really their problem. So you want to figure out who the actual property owner is. Check with the Register of Deeds. You can also get a limited certificate of title through the attorney, and that will show you the history of the ownership and if there are any liens on the property, and you could potentially copy any lien holders on those violation letters. And then again, you might want to send it either certified mail or do a mailing affidavit, or both. And so the street address may not be enough information. You should probably give the parcel ID and the legal description, and that way it is, you know, definitive, and it should match exactly what's on the deed. Again, renters versus landlords, who created the violation, whether it was the landlord or the tenant, we would want to work with the landlord, and then they would work with the tenant if that's the issue. Again, abatement is something that can be done where the cost is added to their property taxes. And then the lien on the property, they would pay that with their taxes. And again, the tenant wouldn't be paying that, it would be the property owner. So that's why we're finding them, locating them. And then if you are dealing with a business, if you go to the Kansas Business Center, you should be able to find the representative agent for that business, who may not be the property owner, but the person that's authorized to act for and receive their mail. So another tip on finding businesses, so this is what it looks like. You just search for it, and then it should pull up all of that information that you would need on who to contact. So the violation letter is kind of like a BLT. It has these certain components that we're looking for and these different layers. So this is a bad example. So you have the opening, explain the violation, the citation from the ordinance, you want to request the meeting, explain what the consequences could happen, set the deadline, and then put a conclusion where they can reach out to you. So in this example, it says you are now in violation. It also says to whom it may concern. We don't want to put that. You want to put someone's actual name on there, because to whom it may concern could be anybody. And then it says you're in violation of the regulations, and it doesn't cite what happened. It doesn't even explain the nature of work. It just says work on the property and you're in violation. And it's in all caps and it's bold. And then it just kind of talks about the regulations. It just says the resolution number, and it doesn't say anything about, again, the nature of the violation or what rules or how to fix it. It just says it's a misdemeanor. You could be paying $1,000 a day for this. And then it just kind of randomly says that you could get a LOMA, which is a little bit strange. If a LOMA is something that can help you resolve the violation, which I think that's valid because a LOMA means it shouldn't have been mapped in the floodplain in the first place, is something you can discuss with the property owner. I don't think it belongs in the first notice. And then it says you can find them at the floodplain management office at the courthouse. But again, it doesn't say what rules have been broken. And then it says 30 days in all caps and it's bold, which again, we do want to put a deadline, but this whole letter is just a little bit threatening, and it doesn't really give the contact information at the bottom. It just has the signature. So this is what we'd want to avoid. Again, the deadline is important so that they have you know, a date that they need to respond or do the action by. the response due date, and that will help people to not hopefully procrastinate too much. So again, look at your violations section for your provisions on pursuing violations and what procedures are followed. So again, if it's a little bit lightweight, we might want to work on that. I'm happy to help you with that. Right, and so you want to have it written out to, again, remain consistent, and if you follow the same process every time, you shouldn't have issues with people feeling that they've been treated unfairly. And then you might want to look at the other departments in your community at their violation section and what their set of procedures are so that you might align with that a little bit more. Keep that consistent because violations might cross over between departments. So if that's the case, you'd probably want to work together to make sure that everybody's on the same page and that when you issue the permit, they're not still in violation with another department because that might, cause issues for them. So for example, setbacks and floodplain management go together. And if they are in violation of multiple things, maybe you just put it all in one violation together. And then again, the due process, we want to give them a deadline, but we need to give them enough time to respond. So usually 30 days on the first one, 30 days on the second one, and then after that point, we can move forward with enforcement. Again, it is important to work with your city attorney. So this is our current violation section template. So I've just kind of bullet pointed what each of these sections addresses. So the first one is inspection and how you're going to do that. And so I did mention this earlier. The first part is doing an investigation, and hopefully you are able to read that. The floodplain administrator shall provide notice of entry by mail, email, phone call, or personal delivery to the owner, the owner's agent, lessee, lessee's agent, whomever, whose lands will be entered, and if these persons can't be found, the administrator shall affix a copy of the notice to one or more conspicuous places on a property for a minimum of 5 days prior to entry. So this is what I mentioned earlier, getting permission from the property owner if you can, and then if you can't, do this copy of the notice on a conspicuous place of the property. So that should work for you to be able to reasonably enter and do the inspection. The first choice, of course, is to have talked with the actual property owner. That would be best so that they know, again, because we don't want you to put yourself in danger. We need to be careful. Second one, documentation, getting permits, building without a permit. Compliance is presumed to be in violation until they get a permit. Violation notices. So this is talking about the letters that you're going to send out. It says certified mail in our template. Again, the mailing affidavit could also be used with the return receipt requested. And that way, this is in here just letting you know that you will send violation notices. And again, that's part of the due process. And then instructions and deadline to request a hearing before the appeals board. And if no hearing is requested, the deadline by which the violation must be corrected. So the notice and the deadline in there. And then 4 is about the fine. Basically, each day could be considered its own violation. Then you set the fine amount within $500, and doing enforcement. It says the lawful action as is necessary to prevent or remedy a violation. And then abatement, which I mentioned. Basically, the public officer is authorized to abate or remove the conditions causing the violation. And then again, you would put that lien on their property so that they pay for the abatement. And then if you do, notice will be provided to them. Basically the same thing, doing notices for abatement in that section, and then the abatement lien is talked about at the end. And it has those citations for our zoning laws in the state of Kansas that authorize us to do that. And so this is what we currently have in our violations section of the template ordinance. So again, take a look at yours and see what it says about how you can do enforcement. And then I'm happy again to help anyone that wants to change their ordinance. So this is the due process language in the Constitution and the 14th Amendment. Citizens expect due process, which makes sense and is fair to give them some time to take action or respond. So yeah, the reasonable opportunity to correct a situation, which has been, ruled on by the Supreme Court and everything. So send at least 2 written notices before proceeding on to the more harsh action, such as fines or litigation. I think in here in the next hour, we'll take a look at our template violation notice, at least the first one. And then, as I said, I'll follow up with the email that has the 2 templates in it. And then there is a section in there about how they can appeal things, because that is a part of their due process as well, how they can appeal your decision and, would go to the appeals board. And that could mean, applying for a variance. They have the right to apply for a variance. Whether or not they actually qualify for one is a completely different story. And we will be talking about variances in the next section. And here's Steve again. So you can make us the bad guy. Again, copy letters to us. It might give your letter a little bit more authority. Again, you can blame things on me. Just let me know what's happening first. And then again, I can try to step in as the objective third party that's not part of that community to try and talk them through the regulations and how you're required to do enforcement and back you up in saying that what you're doing and saying is correct. So sometimes that can help. Yes, again, and we might step in and do a violation notice if they have, for example, violated the state law by putting in fill without getting a permit from us. So again, those rules are completely different from the NFIP, just pointing that out. Yeah, that's when the state violation notice and that gets involved. It's completely separate from the NFIP. So again, check with us if you're not sure if you need a state permit, or sorry, your applicant needs the state permit. So this is the first part of dealing with the enforcement, doing the investigation, gathering that data, doing the homework, notifying the property owner, meeting with them. And again, hopefully you can just get a resolution at that point in time. When it can't be reached, then you might end up going to court or doing the fines or the abatement after that point in time that you've done the 2 notices. And then you don't have to sign up for the meeting with property owners because we're going to do that next. But first, we're going to do the first poll question, and then we'll take a quick break before we come back and do the second part. So again, if you want the credit for this class, I do need you to participate in both poll questions. You don't have to get them right, but I do need you to participate. So when does enforcement start? And we went over this a little bit. When you become aware of it or you get an anonymous complaint, when you visit the property, or when we do an audit. So I'll give you a few more seconds to get your answer in. Okay, it looks like 11 of 11 have.
And Cheyenne, while they're doing
Yeah.
that, we did have one question in the chat that I attempted to answer, but I thought I'd see if you had other thoughts.
Mhm.
So the question was if they continue to do work even though the stop work order has been served. And I was thinking there's often fines associated with that, but did you have any other things to add to that?
Wow. I feel like, law enforcement might get involved at that point, or you might involve the other agencies that might help you if they're doing like work in a stream. And then like USACE or we might get involved with that. Yeah, that would be really unfortunate and
Mm-hmm.
bizarre. I haven't really considered that if that happened, but definitely let us know and we'd be happy to assist you with that. But that is definitely, I mean, I think that might work against them pretty greatly in court if it were to go to court. So
Right.
I would definitely just continue to document that, and then we'd be happy to work with you, but I haven't really dealt with that situation necessarily. Um, so yeah, sorry I don't have a better answer on that. Okay, so 17 people have responded. I'll give you like 5 more seconds if you're trying to get those credits. Okay, I'm gonna go ahead and end the poll. And yeah, everybody got that right. It's when you first become aware of the violation, however you became aware of it. So let's take a 5-minute break, come back at 2:35, and we'll talk about the rest of the enforcement. Okay, so it's 2:35 and I will jump back in. Hopefully everyone is back from break. Okay, so meeting with violators and resolving the violation. So at this point, we've established that something has gone wrong. They have knowingly or unknowingly committed a violation. We've done the notices, and so hopefully they're responding to your notices and you're able to meet with them and find a way to resolve the issue. Again, we're going into it with court in mind because that is the ultimate resolution. And so FEMA says to resolve the violation to the maximum extent possible. And typically for them, that means going to court is their idea of the ultimate resolution. Because at that point, you've got a legal judgment, from a judge potentially. And so there's really not much you can do after that. We will talk about a few things that you can do after that if you still have a violation that is remaining and then you've lost in court, which does happen. Sometimes lawyers and judges don't understand the rules of floodplain management. It's not uncommon that I work with attorneys that don't uh, work with floodplain very much and are not familiar with it. And sometimes that can work against us. So this story, basically a community had a violation. The city clerk was the floodplain administrator, and without issuing a notice or contacting the property owner at all, as far as I understand, she just went and shut his water off. And so he came to City Hall wondering what was going on, and then she told him that she would turn it back on if he moved some, I think it was just storage of material in the front yard. Um, and so that's not how we do enforcement. We don't want to just go and shut someone's water off, because that could have ended in a lawsuit. So just kind of an example of how enforcement has gone wrong, and why we want a written process and have written administrative procedures, because that is certainly not part of it. So how do we enforce and have that template that we follow each time consistently, again, to not cause issues between citizens? And our template is fill in the blank. It's just too much to fit in the ordinance, and the ordinance is really about the strict, hard and fast rules that we have to enforce. The written administrative procedures are tailored to your community. It addresses your specific processes, and it's just more tailored to what you would do. It fleshes it out. Again, safety issues. Uh, again, this is, one of the more legitimate concerns about doing enforcement. We went over some of the excuses earlier, but yeah, fear of retaliation or being attacked while you're at someone's property. If you can work in teams, if you're going to go to someone's property, that's a pretty good rule of thumb. Just take someone with you. That way you're not alone with the property owner that, again, may or may not be very emotional. Just something to think about. So Steve used to talk about going to a property that had violations. I think they were doing work near the stream, and the property owner was going to lead him to the site where they were doing work in the stream, and then they like pulled a gun on him, and he was by himself, and talking about how he had shot people before, these intimidation tactics. Terry and I have been out just on public property, just, looking at development as part of our audit process, and we've been followed, we've been approached. People want to know what you're doing when you're taking pictures of their property, even if you're not on their property, which is not illegal. You can take pictures of people's property, and not trespass. But I get it, there can be intimidation or legitimate threats. Um, so definitely be careful. Again, work in teams. If you can get a police escort, that would be ideal. That would be great. If you have a working relationship with the police department, um, or really anyone that might symbolize authority a little bit more. It just, you want to be safe. So if you can, meet with them in your office, and then just try to avoid that if you can, or if, again, you're going with them to their property, take someone with you. Um, just for safety. And then, when you do meet with the property owner, so hopefully you're in your office and that way you're on your turf a bit. You'll feel a little bit more authoritative. So be professional, definitely be on time because if you're late, they might try to make the entire meeting about that and try to drag that into what they interpret as unfair treatment. So we want to be professional, be on time. Uh, you might want to mirror their body language. So that's just like one of those psychological things. When you mirror someone's body language, they respond to it better. The blame game. Uh, yeah, you don't want to get into that. We don't really care about who's to blame. We care about finding a solution. And so trying to get them to buy into a solution, basically, like you'll save money on your flood insurance if you bring it into compliance, and there's a discount for getting flood openings in your enclosure. Just trying to get them on board with it. And then we explain what needs to happen very specifically and try to explain it maybe a couple of different ways because people might misunderstand what you're saying. And again, people are often not familiar with floodplain management, so it's probably new information for them. So we run into that quite often, and then people misinterpreting what exactly they need to do, which is just not what you want to have happen when you're trying to resolve a problem that's already there. So turn off your phone, dress professionally. If you have like a shirt with your community name on it, with your name on it, or a name tag or something that identifies you as a city official, you should wear that. So you want to try the reflexive posture if you can, that might assist you. Um, so yeah, don't play the blame game, and it's okay if they end up not liking you. They might go into it not liking you and leave not liking you. What we want to do is develop a working relationship, but again, we're dealing with people that have emotions running high. We might be talking about their livelihood and their business. I've had people tell me that I was trying to shut down their business, which is not true. Um, and I did, end up helping them find a solution, which went the Loma route. Again, because I feel like that's valid, because the Loma says you really are not in the floodplain, and FEMA agrees with that, and so that's valid to me. Um, FEMA might disagree with that, but yeah, they have loopholes with letters of map change. Anyways, just finding a solution, working through the exact issue and why it's an issue, and then trying to find a solution. And I know this is difficult. Again, I've been in these meetings and it's very intense sometimes. But again, trying to get them to buy into it, insurance, talking about their mortgages and that kind of thing. So as long as things are resolved, we don't care about whether or not they like us or whose fault it is. If it's the neighbor's fault for whatever reason, we're trying to stay out of all that and just get it resolved however we can. So we want to give specifics and make sure that they truly understand what exactly needs to happen, what their options are. Another of these like psychological things that might help you is reflective listening, which means you just kind of repeat back some of the key words and phrases that they're saying and repeat it back to them, and it might make them feel more like you're listening, and it might improve communication. So again, just a little tip on that. So after you have met with them, we've done the notices, and hopefully this is the meeting where we're getting things resolved. After we've done that, we want to send another letter to summarize everything that we've said and give them a bullet point list that spells out exactly what they need to do. You might have to define some terms, tell them exactly what the lowest floor is, because that's been confusing for people. Just these terms that we use all the time that are in the ordinance that they may not be familiar with. Again, we don't want to cause further issues due to them having a misunderstanding. And then be sure to thank them for meeting with you in that letter, even if it did not go well. Again, I've been there, but we want to remain professional and hopefully thank them for taking the time to meet with us and hopefully finding that resolution. So be polite, and that way no one can claim that you were rude to them, even if it's, difficult to be nice or to communicate with someone who's, yelling at you. Um, we do what we can to just find a resolution. We don't, care about the emotions or anything. And again, I'm here to help you if I can. I talk to emotional people almost every day, so I'm pretty used to it at this point. And this letter will provide a written record of what was agreed to in writing, and then that's part of our documentation that we have for the case file of getting the violation resolved. You have all of that previous homework, your previous notices, and then we have this follow-up letter to hopefully document that this is what we agreed upon. So hopefully that will work. Again, how did it happen? Was it on purpose or unintentional? We don't know necessarily. People will probably claim it's unintentional, whether it was or not. Again, we're trying to do outreach so that people don't actually unintentionally do a violation. Yeah, intentionally or unknowingly, they did a project without obtaining the permits. And again, some people do want to just ask for forgiveness if they get caught rather than do the permission to build in the floodplain. And October 12th, I'll be talking all about permitting. That's our next training that's coming up if you have interest in that. Again, doing the outreach will hopefully help you avoid this happening, and that you're watching. You're looking for people to do permits. You know where the floodplains are, and people may be discouraged from doing the intentional violations if they know that you know exactly where the floodplains are, who they are, that they're in the floodplain. Again, that annual mailer that I talked about doing. I have had some communities start taking me up on that and are doing that outreach. And so hopefully that will help you avoid both intentional and unintentional violations. And maybe mention in there that the state does audits and that you have to do enforcement. And if we come to your community, we're going to be looking for those permits. Again, you can drag us into it if you want to. And so you have your local permits, and then you might also want to mention state permits for doing fill, or the other types of work, usually in a regulated stream that would require the state permits, and the U.S. Army Corps of Engineers might need a permit for that type of work. The Endangered Species Act is something else that might come up. So if you have large swaths of undeveloped floodplains, you might have endangered species habitat in there, and that would require a permit depending on the nature of work, when it was going to take place. And so that's something else I talk about in permitting, but just something to be aware of that FEMA is really cracking down on is that endangered species documentation and those permits and stuff. So I will talk about that again next month. And I was going to say something else about that, but I don't remember. Anyways, yeah, if you're not sure, check. Oh, that's what I was going to mention. The Kansas Department of Wildlife and Parks has a by county list of species. Just in case you're curious if you might have that, just something to be aware of. So what can happen, even if they did and go get a permit from you, they constructed differently than the approved plans, which is something that can happen. And as I mentioned, we're dealing with this right now where they misread the elevation on the stake or something. They made a mistake somehow. Even though it was, staked appropriately, they ended up building the floor a bit too low. And so they unintentionally constructed differently from what the approved plans were. And so that is something that can happen. Incorrect site information is provided. The site changed from submitted plans. Surveyors or engineers can miscalculate things or make a mistake. It happens. Everybody makes mistakes. And so you doing the inspections ideally before, during, and after construction is important to maybe help you catch that before the construction is completed. So we'll talk about inspections, but really during the construction, while the lowest floor is being put in is really the most important one. And so you might go out there and meet with the contractor, if you're not a surveyor or an engineer, you might need that technical assistance from their contractor to show you, how the elevations are, compared to the base flood elevation that you've looked at, and, go over the site plans, which I know is maybe asking a lot of you, because again, I know you are busy and you have other duties and you're wearing 5 or 6 different hats. It's just another tip and tool that we have to hopefully avoid these situations from escalating, because like I said, that low floor violation is now causing a lot of issues for that community. And of course, the contractor um, and the property owner that now needs to elevate in place, and that is pretty expensive to do. So if we can avoid that, that would be great. So another example that we have that Steve used to talk about is like a ranch style house. So it was a rectangular ranch style house, and it was fine, but then they decided they wanted to reorient the house and just like rotate it so that the sun would shine through the windows differently, is what they were saying. But then they wound up getting into a power line wires easement, and then it was a floodplain issue as well. So, things like this can happen. And so on our template permit, which I should probably also send with the follow-up, just in case you want to see what we have. Again, I'll be talking about permitting next month, but it kind of serves as a checklist for all the things you need for compliance. And so you might want to take a look at your permit form and just see what's on there. And if there's anything that we have on ours that might be of assistance to you. But it should say somewhere on there that the permit will be revoked if not built to plan. And it should also say that you have permission to enter the property and do inspections. And so that way, by signing off on the permit, they're also giving you permission to enter and do inspections and stuff. So again, there's a little bit of overlap with permitting and stuff here. Another example that we had was where the project was staked out for a new residential structure. And then the property owner came out and like pushed the elevation stake into the ground, like by a foot or something. So when the contractor got there, they started building, and then they completed the construction. And then the floodplain administrator found out what had happened, which is unfortunate that a property owner would do that to themselves. But then we found out about the violation, and then it has to be elevated. Whereas it could have just been built to elevation in the first place. But of course, new structures like that are required to have a finished elevation certificate. So that at the very end of this, you are checking the complete construction is compliant. So again, that's where the inspections come in. If you can stop something before it happens, that's, easier to deal with than you having to enforce them to elevate a completed structure. We don't want that. It could be that you have deficiencies in your local permitting process. So again, this is something that we would address when we're doing the audit. Sometimes staff is unaware of the requirements. Again, this permit should be working as a checklist, and it has instructions on it for each section. Communication is key for sure. Again, the sign permit is a document that gives you permission to enter the property and do those inspections. So again, we want to put in special effort on checking the lowest floor, and also the ductwork is something that gets missed a lot as far as violations. That is also required to be elevated, so checking that. Sometimes citizens don't understand the requirements, like they say they do, and neither of you know that there's a complete misunderstanding there. Like when property owner had built a basement And they said, you know, the lowest floor has to be 1 foot above the base flood elevation, and they were thinking that it meant the ceiling area of the basement, and so it was, you know, 8 feet lower than it was supposed to be. And, you know, there's no new basements in the floodplain, and that's something we deal with a lot in this area of the country, is that people are always wanting to put in basements, which I understand that, but no new basements in the floodplain. So that's a very common violation or potential violation that we encounter, is seeing site plans for basements or basement expansions that are going to be a substantial improvement. And if they do that, then they would have to fill in the basement. So it, you know, things like that are pretty common. Lack of adequate local resources, including professional staff. We're happy to help you review site plans and, you know, potential permitting and work with you on the compliance. We can't really sign off on or review no-rise certificates, because those are, you know, the work of a licensed professional. Um, but, you know, if they're, you know, signing off on something and certifying something like that, their license is on the line. But there are tips on how to review those. Just putting that out there. Does your permit form state that you have the right to do the inspection? If it doesn't, that is definitely something to add. And then that it will be revoked if those conditions are not met, or if or incorrect information is given. So just a few tips on your permitting process and the form. Um, if it was, you know, a problem with your ordinance or permitting deficiencies, I am happy to help you with an amendment. If you have an older ordinance that might have a loophole, or something like that, that contributed to the problem. Higher standards is another thing to keep in mind. If a new development is not meeting your higher standards, that's still a violation, even if it's meeting the FEMA minimum requirements. So it is always better if it is at least meeting the FEMA minimums and the state minimum requirements, but we are required to enforce our regulations, and that includes higher standards, which sometimes gets missed. Again, this might apply to an older ordinance. I've seen some ordinances that are still in place from the 1980s, before we even had the state higher minimum. And so, you know, we're working through some of these older mapped communities, and that's why they're so old. They haven't had a map update. So, you know, things like that, take a look at when your ordinance was updated. And then the rule of thumb is if it's been 10 or more years that we might want to consider updating it. So yeah, and there's like the manufactured home FEMA minimum exception to have it 36 inches above grade, but that doesn't comply with the state minimum. So if you have that in there, that should definitely be taken out. And again, looking at your violation section in particular, and seeing if that needs any improvement, and, you know, comparing it to what I showed you earlier with our, you know, state template that we have now that addresses all of those different areas, including the inspections and abatement and all of that. So just take a look at that. Okay. So again, change or adopt those procedures to have this in writing. That's really important. And another document that will support you in court is having that internal document that outlines exactly, and it's just going to make it easier for you to follow a consistent process, and it'll take some of the guesswork out of it. Go, how long was it ago that I sent this notice? If you have it in writing, then you can put it on your calendar. Okay, this is exactly 30 days. I haven't heard from them. It's time to send the second notice. It's time to do the inspection. It's time to try to meet with the property owner. And that way it just, it's easier for you probably to do enforcement if you have that. Of course, you have to require the permit applications, issue the permits in a timely manner. That's another thing, that if permits are taking too long, people will try to build without them. So just having that a turnaround time on doing permitting. So the administrative procedures have, you know, a lot more sections than just how you're going to do violation. And again, violations and enforcement. And again, it ties into the permitting process. They're pretty well linked together. So having a turnaround time in there to make sure that permits are issued in a timely manner. And that includes that inter-office routing procedures. So again, you might have other departments that need to approve things on a floodplain project. And so making sure that everyone knows the timeline of that and who it needs to go to next and getting it done again in a timely manner. So that's part of it. Training your staff. So other departments might not know this stuff. They might need to be educated a little bit on permitting requirements and floodplain rules and stuff. And that way they can identify things and make sure that you are aware of any new development that they come across in the floodplain. That might also assist you in addressing violations or preventing them. And having that communication between departments. So hopefully you have a good process in place and you're able to establish that line of communication, and so that other departments are not missing you if stuff is going on in the floodplain that they know that you need to check that out and verify compliance and do the permitting and all of that. And this is important, again, I mentioned aligning your violations and enforcement process with the other departments. That we have had situations where different departments were doing different things, where one issued a violation notice at the same time that they were getting their certificate of occupancy. And we definitely want to withhold the certificate of occupancy or OCC until everything is approved and in compliance. So that is a great tool to have to get compliance. So as I mentioned in that low floor violation that we're dealing with now, when they went to get the OCC is when that violation was discovered with the low floor, and they didn't get that. So they can't get that from the community. They can't, get utilities started in that construction, and that is or that structure, and that is another tool that we have, if we're withholding that to get the compliance. And of course, we wouldn't want another department to be issuing that if we are, trying to fix something. So certainly you should understand your floodplain regulations. Again, I'm happy to work with you or try to explain regulations or why we regulate things, or really any questions that you have. I'm here to assist you. Hopefully you can interpret your maps. If you have questions about the maps, we have an excellent mapping team here on our floodplain team that can help explain things to you. Hopefully you have access to that. I know it is harder if you have older maps that are still on paper and you have to, use the paper maps to find things and do determinations. I mean, we have digitized them on our floodplain viewer, but it's not entirely accurate perhaps as far as like the georeferencing, and it's really old. So we are constantly trying to update maps, but it takes a very long time. So hopefully you're able to use your maps correctly, understand and use the proper permitting procedures, because again, those procedures are in place to help you catch and prevent violations. And then of course, if it happens, we have our enforcement procedures. Hopefully you know how to use our site. So we have the effective floodplain viewer on there. You can check on mapping projects there. I don't put them on. My newsletters are on there, and I try to write, brief articles that, give you an understanding of floodplain rules and like common problems is what I try to focus on. So those are on there. The state regulations are on there, when you might need a DWR permit. So there's lots of resources there on our site. If you don't use it very often, you might want to take a look. And of course, everyone should attend training. So I commend you for being here and, thinking about enforcement and violations. Of course, you probably know where our training page is if you're here. But if you're not, if you got this through my announcements, there's a whole training page, and we put these recordings on there as well. So just throwing that out there. So yeah, you are hopefully able to address any deficiencies that you might have in your program. Okay. So then you understand the regulations, so that way you can tell the applicants exactly what the requirements are. And so hopefully they have a clear understanding. Misunderstandings and miscommunications do happen. It's happened to me with floodplain administrators, so it's something that happens, which is why I said try to explain it maybe a couple of different ways. Not to make anyone feel stupid or anything. It's just, sometimes I need multiple explanations of the same thing to really understand it. So those requirements that are really important, such as elevation and openings, uh, definitely, you know, the more common ones, and can be expensive to do the retrofit. And so that's why we're trying to prevent things from being built out of compliance in the first place. So try and put that very specifically and clearly on your permit. And that's why it's in writing. So hopefully they can read through everything and be able to understand it if it's very clear on the permit what they need to do, what they need to provide you as far as site plans and finished elevation certificates. Again, we want to be consistent, and that's where the procedures come in. Again, the OCC, that certificate of occupancy, can be the carrots that we hold at the end of the stick to get the compliance. Like, you're not getting that until this is corrected, and they can't get, they can't rent it out. They can't get utilities in there. So it's a very good tool to withhold that until everything is verified. And again, writing in the inspections in your process. And that way you know when exactly you should be doing that, and that involves getting the construction timeline from your applicant, but it really is an important thing to at least do the one inspection. Um, and that ties back into permitting that I'll be talking about later on, next month in that class. But inspections will help you to not miss anything. So you want to schedule them with the contractor, and that way they're there to, work with you and verify everything. And if you are, if you've made a mistake and the person is not in violation, or again, you couldn't find the permit and then it was just somewhere else, something like that, just admit the mistake, just apologize, and, that will, hopefully keep the relationship working with that person. Again, people may be upset with you for many reasons regarding violations, but a mistake, as long as we admit it, hopefully that is enough. And if we ignore it, will it go away? Not likely. Violations tend to be bigger problems down the road. And this comes up in audits, and FEMA might catch it, and then again, it's a lot harder to deal with if it's been a long time. So the faster you take care of things, the better. We have had situations where the person got a violation letter and then sold the house, and then the new property owner was dealt, with the violation and everything. So that can happen. Property ownership could change, and then an innocent person gets punished. It's just one of the things that we would want to avoid as far as violations. We just throw this in here. It's a great resource, the Kansas BFE portal. So we can calculate a base flood elevation for you in A zones where they, are not provided in the flood insurance study. So this is for zone A's, where the data is available. So we'll provide that to you depending on what you're needing it for. We will give you the appropriate base flood elevation. So you just register on this site, and then you can go to the map and draw in a polygon for a section of property, or you can do it for a structure. And we have the approximate lowest adjacent grade from the LiDAR. And this can, again, help you with solutions such as a LOMA, which is, I would say, a valid way of resolving a violation, because again, it just means that the property or the structure was inadvertently included in the floodplain and it should not have been. So I would consider that admission from FEMA that it's not a floodplain violation. Just and then you can click around and just look at the approximate LiDAR if you want to, and just see if that might help you find a solution for somebody. Okay, yeah, and people will like you more if you can help them save time and money by finding a solution that will help them do that. So this is a great tool and a great resource if you know, check it out. Another common violation issue is having these utilities that service the building not elevated or not anchored. So those are required to be at least at the base flood elevation or above it. And FEMA threw in that requirement after they were doing a lot of payouts on insurance claims regarding like HVAC situations like this one. It was completely submerged, so you can see the high water line on that. And of course, submerging it means that it is no longer functional. It's kind of a complete loss on that system. And so another thing to watch out for is these types of violations on utilities. And then again, trying to get them to buy into solutions. There is a machinery and equipment discount if it's elevated high enough, depending on the type of structure that you have. Again, just whatever tools we have to get compliance, we like to use those. And so just going into a little bit of insurance here, just because, this did change 2 years ago. So it is, I would say, still fairly new and not as many people are familiar with it. And it didn't change for that whole like 40-year period. So kind of a big shift. There's been a bit of a split between regulations and insurance, and it used to be insurance getting really expensive for violations used to be a big tool that we had to get compliance that we kind of have lost to some degree or another. So again, there's a discount for this. So if you have slab on grade, it would have to be to the second level or the attic level or higher, basement to the floor above the basement or higher. Elevated without an enclosure, it'd be on that elevated floor. If it was to have a partial enclosure or a full story enclosure, it's still on that first elevated floor. And the same thing, crawl space, just the floor above the crawl space or higher. Um, this doesn't seem entirely fair based on like a slab on grade would have to be at the attic level compared to the crawl space thing, but this is how they've done it, and they've split it up in this way to these 6 basic foundation types, and then just a little bit of coverage in the basement. But anyways, most importantly here, as far as we're talking about violations, is that it used to be if you had, your machinery and equipment below the base flood elevation, it would change your whole rating floor, and then that could make it like 10 times as expensive or even more than that. That's not the case anymore. It's either you get this discount or you don't. So you're not penalized for that anymore. It's not going to impact your rating floor anymore. They're still doing first floor height. So we don't have that as much anymore. We can use that discount a little bit, but yeah, if you haven't checked out the flood insurance manual, I think that was updated in October of 2021. So if you are interested in that, if you deal with insurance. Um, of course, flood openings are part of the requirements for foundation walls that are in the floodplain, such as a crawl space. Proper flood venting can get them a discount. It's kind of a range on that one, depending on other building characteristics. And the same thing, you can get mitigation credits on your insurance based on your lowest adjacent grade, first floor height, foundation type. So a little bit here that might help you with compliance. Again, it's not like it was before, but just a little bit on insurance here. So yeah, there are some credits and discounts available based on those characteristics, and that might be a tool if the person is required to have flood insurance, as a condition of their mortgage. And then risk rating 2.0, they have the risk rating engine that we don't have access to, so we can't really look at things or tell them what their premium is going to be, but this is all the different things that factor into it. So I just wanted to cover that briefly. You have the cost to rebuild, your previous claims, catastrophe modeling. The FEMA mapping data used to be pretty much all that was used compared to their lowest floor elevation, and that's not the case anymore. First floor height is the first floor that's above grade. So that's what they're using. And then all of these other factors. So just a little bit about insurance and how that has changed and how it kind of factors into violations and compliance. It's just not as useful as it used to be. So as I promised, I would talk a little bit about substantial improvement and damage. So again, it's either the cost to improve or the cost to repair to the previous condition between improvement and damage. They're kind of the same thing. So if that is equal to or greater than 50%, it would have to be brought into compliance, which again means the current base flood elevation, which typically means they would have to elevate the structure if it's not already elevated high enough. And of course, we have the 1 foot of freeboard rule that factors into that. And so this is again where compliance and violation comes into play. People are very reluctant to try to elevate an existing structure. It is expensive, but it is again part of our enforcement that we have to do. And to consider that people might be investing in structures, like maybe their whole life investment into something that is at risk for flooding. And, it has like a 26% chance of flooding or something like that. Over the life of the mortgage, like a 30-year period, there's, a high chance of it flooding, especially if it's in the special flood hazard area. So that's why these rules are in place. We wouldn't want them to be investing money in something without elevating it appropriately to that existing, base flood elevation and the freeboard. So just kind of why that's important. And so if we're talking about a manufactured home in this case, they're typically not super valuable, so it's easy for them to hit that threshold. And that's why we try to track substantial improvement on the permit forms and, watching out for phased improvements. So FEMA 480 kind of suggests a rolling 1-year period, which is a suggestion, but really we're trying to look for those phased improvements and still count them all together no matter how long it's been, really. So there is no hard and fast rule on that unless you're doing cumulative improvement, and then it's a 5-year period. That window, anything damage or improvement wise is tracked with those permits, and then you want to let them know how close they are to that threshold, and that improvement and damage are going to be counted together, just so that they're aware, and again that they would have to elevate their structure if they hit that limit. So I did talk a little bit about first floor height, just a little bit. This is going back to insurance, so that's in here. If you're curious, these are from the flood insurance manual. Just was looking at that and how they've broken down foundation type. Again, they've kind of condensed the 9 from the elevation certificate into 6. And then the new elevation certificate just came out. But I'll be talking about that in November if you're interested in that. The statute of limitations is another thing that we need to be concerned about as far as violations being a misdemeanor crime. So we have a 5-year limit on that. I mean, some attorneys have said that every day a violation exists is considered a new violation. So that is in our template ordinance and everything. So I'm not sure if that really factors in. Like when we're doing audits, 5 years is as far as we're looking back on things. So again, technically, as soon as you become aware of a violation, it's still valid. It just may be harder to do the enforcement as far as your legal avenues if it's been longer than 5 years. So there's some disagreement on, when it is considered a new violation, and FEMA has said that it, counts as a violation separately each day. But yeah, just something to be aware of here that must be commenced within 5 years after it's committed. So that could come into play if you go to court and it's been a violation that's been there for more than 5 years. Another reason to act quickly if you can. again, if you don't deal with it and then FEMA finds out, they're still going to want you to fix it. They notified us about something where someone tried to file a letter of map change on something that was built back in 1999, and there's a low floor violation on an accessory structure, and they're still trying to get us to do the enforcement on that. So again, um, people trying to file for LOMAs or other letters of map change is often a way that FEMA finds out about violations, and then they do follow through on you getting that into compliance. So just to be aware of that, if that should happen. FEMA once made a community pay for the elevation of several houses because it was kind of their fault for not doing the enforcement when they should have. And then, the city council is not pleased. So if you put yourself in that situation where you have to tell city council that the city will be paying to elevate several structures because you didn't do enforcement, is definitely something to think about, and how they would feel about you if that were to be the case. So just we want to do enforcement, and that would be a really unfortunate thing to happen. And then, of course, variances. As I mentioned before, there are people who want you to award them a variance to resolve a violation that they created. And they might even think if they get the variance that that would take away the flood insurance mandatory purchase requirements. None of that's true. Um, Variances are not a tool for violations, not in any way, shape, or form. Variances are for properties with unique site characteristics that are so um, unusual that they warrant a variance. So going by the specific criteria, there are very few cases that actually are eligible for a floodplain variance, and it's definitely just not a violation tool at all. That has zero relationship to that specific criteria and the written justification. I've also been asked if people can opt out of floodplain requirements and then just not have insurance or disaster assistance or anything, which I kind of understand the merit of that a little bit, but there is no such thing as opting out or waiving of permitting or compliance requirements, even if you don't want insurance or you promise you're not going to ask for disaster assistance. That's just not how the laws work and are applied. If you're in a community with a floodplain ordinance, you have to abide by it no matter what. So just another side on that. Again, kind of relates back to that low floor violation. They applied for a variance without any proper justification. So we're waiting for that to play out. Again, they have the right to appeal, and we let them know that. Again, we don't want to violate their rights, so they have the right to request a variance, but they would have to find the appropriate justification for it, which they don't have. So, we're waiting for that process to play out, and then I'm not sure what's going to happen there, but FEMA is aware of it and they are following through on that. So, we'll see what happens there. Again, regulations and insurance used to play hand in hand, but they have kind of updated insurance without really updating any of the regulations in the Code of Federal Regulations. So there's a bit of split up there, and we talked about that. But again, you can play their insurance costs and possibly getting discounts on that. So variances are for property and not personal in nature. It has nothing to do with the applicant. And I know the wording in the ordinance says hardship on the applicant. It means the hardship on their use of the land. It has nothing to do with their personal circumstances. And I kind of wish it was worded differently because people get that impression that we're talking about the actual applicant as in the property owner and their justifications, which have nothing to do with floodplain variances that pertain only to the land. So I, again, wish that was worded differently so it has nothing to do with their disabilities or their financial situations, or anything like that. But the ordinance does go through these requirements. Will not increase the base flood elevation, so that's pertaining to floodways and getting the no-rise certificate. No increased flood heights, no public safety or nuisances, extraordinary public expense, fraud or victimization of the public, conflict with any other local laws or ordinances, and it would be the minimum necessary to afford relief, again, pertaining to the use of the land and its unique site characteristics, and nothing at all to do with the actual applicant. But I get these all the time. Um, and there's a lot of reasons, it could impact the property value, inconvenience the property owner, their financial situation, um, aesthetic concerns, which I did also hear with that low floor violation, or hardship created by the owner's own actions. So again, violations, not a way or any kind of justification to get a variance at all. And this happens quite often, and that's just not the criteria. So making sure that your appeals board is very familiar what the floodplain criteria is, because FEMA will, crack down on this and they don't want to see variances and they might find out about it. And sometimes boards will approve things that they should not, which is why you should give them variances in the NFIP to make sure that it's very well understood that we don't consider the personal circumstances or anything about the property owner themselves at all. And then of course it is the requirement that if you do grant a variance that you tell them in writing that it could increase their um, their insurance premium rates if they constructed below the BFE, and that they may be at increased risk to their life and property. And then that is maintained with a record of all of the variance actions and their permit files. Again, variances should be very, very rare unless we're talking about wet floodproofing an agricultural structure or a functionally dependent use. And those things have been, written into guidance as completely different if we're talking about like a residential structure, totally different. And then of course, if you send them that, you should also send them a snorkel, a life jacket, and swim fins, which was one of Steve's jokes, of course. But it is a safety concern. Again, that's a lot to do with it, and you could be held liable for the things that you approve or don't do enforcement on. And that is another thing to be very aware of. So yeah, they actually gave him a little floaty when they approved his variance. Of course, you won't be smiling if you actually do get flooded and you didn't elevate high enough. So there are cases where, again, a variance could be a solution for an agricultural building. So again, we just updated our template and FEMA clarified the agricultural structures need variances to be allowed to be wet floodproofed because they're so diverse in what they are. A cattle operation is completely different from a corn crib, so they want you to take that into account, all of these unique characteristics of a structure, and then give that consideration through the process of a variance to allow it to be wet floodproofed if it's low damage potential. And so again, that is completely different. You could do that, or an accessory structure, or functionally dependent use, such as a boathouse. Very different from other types of structures, other non-residential and residential structures that are not part of these exceptions, you might say. So those are different types of variances. I consider them to be completely different. But there is, again, this book is important for your appeals board, variances in the NFIP that talk about all of the criteria, and you just want to make sure that your board is educated and ready so that they're not approving things that they shouldn't approve. And a lot of justifications go back to the property owner, and that's not part of it. So again, variances can draw attention to FEMA, and they may review your findings and what your justification was for granting those variances. And if you're demonstrating a pattern of inconsistent criteria that doesn't, fall in line with the objectives of floodplain management, they may do the probations and the other sanctions that would apply to that. And then people would get a surcharge on their insurance policies. And again, that will not make you very popular. So just, again, consistency and making sure that you don't approve things that are not in line with the actual variance criteria. And of course, insurance, those variances can come back to us, come back to FEMA, which is the network of spies, basically. If when FEMA finds out about it, they will be, upset if you're approving those types of variances and they're not properly justified. Um, Although I'm not sure if this still works as much with risk rating 2.0, I would think it would because um, would have applied more to the submit for rate type of policies before, but now it's kind of like everything is submit for rate, where they're looking at all these different characteristics. So I would think a variance would probably pop up in that. So it is a possibility that it could get to FEMA, and then FEMA will make us actually do the inspections and everything. So again, going to court, they have the right to take you to court, or you might take them to court. If the variance is denied, so that's the denial of their appeal, they might go to court, you might win or lose. And then some people think if they ignore you, you'll go away. So again, be prepared to go to court as the ultimate step if you can't get compliance. You might have to take them to court. Hopefully you have legal staff that you can work with on this and that they are at least somewhat familiar with floodplain stuff and have you maintain those records and document it thoroughly. As we discussed, is really important for this reason. Be prepared, have a pretrial meeting with the attorney, refresh your memory of all of the different steps and aspects of the case and go over your notes. You want to dress appropriately, turn off your phone. You might have to testify, so speak clearly. Remember, not everyone is familiar with the NFIP and your ordinance, so don't use acronyms. Think carefully, take your time, stick to the facts, be honest, ask them to repeat a question if you need them to, look at the judge or the jury if they are part of that. And so, yeah, attorneys will try to trip you up, so just take your time, listen carefully, and again, ask them to repeat the question if you're not sure. And your handwritten records might be challenged. So make sure that you're writing legibly in all of that documentation that you've been keeping on the case. And if you lose in court, there's a notice on deed or the 1316. And this is, again, after you've gone to court and it's still in violation. So this is like a zoning affidavit that you can put on the deed, and that way any prospective buyers will see this, that it's non-compliant, and it's something that you file against the title, and then that can create an economic incentive for them to fix the problem. And that way the potential buyer is notified, because we don't have disclosure laws in Kansas, and so people are not always made aware of the flooding history or that something is in violation before they actually close on a property, which is not great. But here's an example of the non-conforming zoning affidavit. And that way they will see it, because again, there's no disclosure laws, and that can be an issue with the 1316, which I'll talk to in a minute. So make sure the legal description is exactly correct and matches the deed. Specify that regulation, that citation, the year it was adopted, the map panel and the effective date of the map. And then you don't take that off if it's corrected. You just post a new notice on top to let them know, to document that it was corrected. But those stay with the deed permanently. And so 1316 has issues. So the notice on deed may be the better choice, or you could potentially do both, I would think. If you lose, you can request that FEMA put this on the 1316 list that will deny flood insurance coverage to a building. And so that means they wouldn't be able to get an NFIP policy, and that could punish a new owner that doesn't know anything about being on the 1316 list, because sometimes they don't find out until they go to try to get a policy, and that might be a requirement of their lender, but they can't get it. So then they might have to go to private insurance. So we don't want to punish people who had nothing to do with the violation. And it's, again, not about punishment. We're just trying to get compliance, but that does seem unfair. But if you do this, they can't get the NFIP policy. They don't have grants or loans. They're not going to get that federal disaster assistance. But again, it's not perfect, because it could punish a new buyer who had no way of knowing about this beforehand. If the property owner who has an incentive to sell probably is not going to tell them that either. So it can also be cumbersome. There's a lot of bureaucratic hurdles involved. So again, the non-conforming zoning affidavit or the notice on deed, it might be the better and simpler option. And again, it will prevent people from being caught unaware when they're looking to buy a new property. And so lastly here, talk to people about flood insurance as part of your permitting. It's important. I know it's expensive. People don't like it, but it really is the best way to recover. Disaster assistance really isn't that great. You're not going to get anywhere near what you get for a flood insurance policy. There's the ICC claim, which is $30,000 to help them bring something into compliance if they're substantially damaged as part of the standard flood insurance policy. So that is a great benefit, even if 30,000 really isn't very much to elevate a full structure. I do realize that there is talk of increasing that amount, but really flooding can be devastating. They can lose their entire investment, and that can really ruin someone's whole life and financial situations. And we've seen it happen, and it's very sad. So talk to them about insurance, visit our website. I will probably put this in the follow-up as well, just so you're aware of some of the other resources on our site. And of course, the FEMA publications and technical bulletins can help you really understand the intention of the regulations and what all needs to happen. Of course, let me know if you need help with anything, really. If you need any publications, of course, and just driving it home, you could be held liable potentially if you're not enforcing the adopted ordinance for being negligent. Again, if someone gets hurt or is killed, it's going to be a very big deal, and you could, face consequences for that. So it can be very serious. Just not to scare anyone, I just want to make it clear. And then, of course, the state laws about, well, this is about, your liability as an employee. So, yeah, unfortunately. Sorry, we're a little bit over. I apologize. If you want the CECs, we're going to launch that poll question real quick, and then we can just wrap it up with any questions you guys have. So last poll question, again, you must participate if you want that certificate. It's a little awkward when I can't tell people that they don't get credit. So which activities constitute development in the floodplain? Filling and grading, storage of materials, repair of damaged buildings, roof maintenance, or all of the above? And I did try to make these questions a little bit easier to follow along, so hopefully this has made sense to you. So we have answers still coming in. I'll give you guys probably another 20 seconds to get that in, and then we can wrap it up. Okay, last 10 seconds if you want the certificate to put in an answer. Okay, I'm gonna go ahead and end the poll now. Okay, so yeah, all of the above. Of course, any man-made change is development, and so yeah. Okay, so sorry, you have to jump off now because we are over time, but if you have any questions, feel free to come off mute. I'm happy to answer them. Stop share. And then, of course, if you want the certificate and you answer the questions, send me an email and I'll get you a certificate, but I'll also put that reminder in the follow-up email. But yeah, just let me know if you need anything, any of the resources that we talked about today, or anything else. Otherwise, I appreciate you guys being here, and I hope you have a great rest of your day.